So as health practitioners, and I mean, generically, all of you, you, in the course of your providing your services, as it were, obtain consent from patients, consumers, people in your services, right? So you assess their capacity, because one of them, we'll get to that, because one of the key criteria in health law around informed consent is to medical procedures or provision of services, admission into a rest home, whatever it might be, is capacity or competence. Now, in New Zealand law, we use those terms interchangeably, okay? So, whereas Albert might have referred more in the North American context to competence, it also has a meaning for clinicians as well. But in law in New Zealand, and generally now, we've sort of started to use, you can use those terms interchangeably. So, in the Health and Disability Commissioner's Code of Patients' Rights, I just tend to call it the HDC code. It actually talks about competence, but in our main adult guardianship law, it talks about capacity and competence. So let's just sort of treat those together. So my main point here is that all of you are involved with assessing a person's capacity, because one of the key components to informed consent is that the person is competent to give consent, or indeed make an informed choice that might be a refusal of treatment. Okay, so, and I add to that all of us involved in the mental health system, and including lawyers and judges, assess a person's capacity. So, as a lawyer in a whole variety of contexts, I mean, I'm dealing with people with impaired capacity. I may not necessarily making decisions on their behalf, but in terms of whether or not they have capacity, but all of us as professionals involved with the care of clients need to be thinking about the fact that actually we're assessing people's capacity all the time. It's just that we don't necessarily stop to think, has this person got capacity, because they may well be compliant by just their actions in agreeing to it. So capacity, why is it important? It's important because it's about whether a person's decisions or actions are valid in law, and if not, who decides and how those decisions are made. So it's not only about having legal standing in law, it's having what we call legal agency, be able to act on your actions. And so we talk about this bright line in law, which is if you have capacity, you're allowed to make unwise, or we talk about New Zealand law, imprudent decisions. But if we're over that line and we lack capacity, then other people will make decisions for you. We can call those substitute decisions. And the standard by which those decisions are made in the person's best interest, we talk about in law. And that's another thing. In our New Zealand law, we haven't actually codified what we mean by best interests. And there is quite a lot of international talk in literature and development in other countries where they've sort of started to say, well, actually, taking into account a person's best interest is no longer just a paternalistic view of what the doctor thinks best, but it actually means taking into account the person's will and preferences and building that into a decision about what is best for that person. Now, we're not going to be talking about that side of things, because we're talking about a law where it's going to intervene, and the criteria is around capacity. But just to make the point that those are the sort of two main concepts that we deal with in mental capacity law. And as we know, generally, this applies to a wide range of people. So, and the focus of more recent times, of course, has been the vast increase of the ageing population, people with dementia. In the UK, I think there's something about nearly 2 million people by 2020 will have dementia. Of course, that doesn't mean to say that you lack capacity to make a decision for yourself, but it does give us an indication that there are huge numbers that we're talking about within the health services. So Lepping et al., the researchers reviewed 50 international studies and came up with figures that on medical wards there can be up to 35% people may lack capacity, and in psychiatric wards up to 45%. So, that means that there are a lot of people just even within the health services that may have impaired capacity. So ACC is also an important area here. So there are many people that are turning up to ACC services who have, may have brain injury or, trauma that has quite a big bearing on them exercising their rights and access to services if they're unable to, make decisions for themselves. And then, of course, there are those with learning or intellectual disabilities and mental illness, and which throws up this issue about people having fluctuating capacity, and that's the space we're in with substance addiction as well, that where people's capacity may vary from time to time. So here we're really saying that capacity is important across all spheres of life, essentially, because we need capacity to consent to or refuse medical treatment, admission to hospital. This is quite a hot topic about discharge from hospitals at the moment, and discharges into secure dementia unit. On what basis do we detain, essentially, or confine people into a locked dementia ward if there is no one else who has legal authority to make those decisions for them, and they lack capacity to consent or refuse the treatment? About privacy and sharing of information. So solicitors and lawyers get involved at the front end around property and wills, of course, testamentary capacity to make a will. And as I say, to make, activate or revoke, which means withdraw an enduring power of attorney. To contract, I'm dealing with a case about an employment law actually at the moment about whether the person had capacity to sign an agreement in full and final settlement. So like someone under a lot of mental distress and anxiety at work couldn't remember signing it. So, and then, believe it or not, in the UK there are cases around capacity to marry and to consent to sex and sexual relations, which have caused a lot of angst around vulnerable, what they call vulnerable adults. These may be people who have capacity in law, but may be vulnerable to, abuse through relationships. With, let's say, one case of a paedophile discharged from prison having, sexual relations with a woman with learning disabilities. At what point do we intervene in those kinds of situations? So this slide shows you, these are some of the legislation and the laws. So this is SAPCAT here, and it really sits under that umbrella of mental health law, where there is compulsory assessment and treatment. So these are cases where the law has overridden that right to give consent, because if you lack capacity, you will come in under this compulsory treatment regime. And the same is with the Intellectual Disability Compulsory Care and Rehabilitation Act, 2003. Anyone familiar with that? That's got that has, if you have an intellectual disability and you have committed a criminal offence, you can your sentencing can be dealt with through the health system. So you're no longer part of the criminal justice system and you move under compulsory care. It's actually a unique law in New Zealand. It raises a number of human rights issues around how long you can continue to detain people, continue to keep people under compulsory care, given that they are unlikely to regain capacity or in terms of continue to meet the criteria for intellectual disability to come under the Act. So we do have a backstop or a safety net jurisdiction in the High Court. It's very rarely used, and it's called Parens Patriae, which literally means parent of the nation. So if all else fails under legislation, lawyers like me can race into the High Court and use that. So there are, I have been involved in cases actually where there have been applications for writ of habeas corpus. Now we're talking about going back to 1215 and the Magna Carta, because some of these, as it were, basic rights around liberty and liberty interests, particularly for vulnerable adults and people with impaired capacity, go back to the English law and the development of putting in protections, that kind of bottom line protection of the court through the inherent jurisdiction. So, I mean, just so you know that it's there, but actually there have been several cases in more recent times about detaining people with dementia where families fight over the appearance or someone with a disability and whether or not they're actually being held unlawfully. So we have laws around anti-discrimination and equal treatment under the Human Rights Act. The New Zealand Bill of Rights Act tells us that there is a right to refuse medical treatment, and also to refuse in terms of in terms of the law, which is again a 1990 law, the right to refuse participation in medical experimentation. That's called. The main two laws that really affect the interests of people with impaired capacity in New Zealand is one, the PPPR Act, because it's the adult guardianship law, and this is where most of our law, developments have come through, and the second one is the HTC Code of Rights, because that is in and around the basics. The tradition of mental capacity law has come through medical law and the law of consent, and what do you do when a person can't consent to treatment. So that's the big picture. So here's the code, and as I was saying before, there are 10 rights in the code. There are umbrella rights, of course. There are the things around respect for dignity, as well as ensuring that care is at an appropriate standard of care under Right 4. But it's really these rights 5, 6 and 7 that we're concerned around consent. And the key elements are communication, information, capacity or competence. And to that we tend to add the sort of another component, which is deliberation. Generally, when we think of informed consent as a process where people have an opportunity to, where necessary, to be able to sort of think through making a decision to consent or otherwise to treatment. So, and also the code also recognises the right to refuse consent. And what the code says is that it is subject to other laws. So if we have compulsory treatment laws, such as the Mental Health Act or SACCAT, that can override this basic right to consent. Okay. So the way you have to think about SACCAT is that it's an exception to the right to give consent, and the state, we've all agreed through Parliament that this law can override. And there are other laws too, but let's just focus on the Mental Health Act is one that most of you will be familiar with, and SACCAT is another. So that's, if you like, and it overrides what we would generally regard as a sort of fundamental that people are entitled to have the right to consent and not to treatment and things that affect them. So one of the things around the code is that we haven't developed any sort of guidance around what it actually means to, what does it mean to have capacity or competence to consent. So the code itself doesn't define that. So what we do is we look to the common law or case law, and there are a number of tests that sit there if they're not in legislation. And it's basically around the idea of whether the person can understand the nature and effects of proposed treatment, including the purpose for which it's needed, to be able to weigh up the options, the risks and the benefits, including the likelihood of success and any alternative forms of treatment, and the possible consequences to the person of receiving or not receiving the proposed treatment should be explained. So that's the common law test for capacity to consent, and essentially that's what you will be doing, looking at whether in terms of a person's capacity to consent to treatment under SATCAT. But that's the common law test, so you'll see the similar wording and the same sort of idea based on that. There's another important right, which is not really a right, it's what I call a right override in the code, and it's an exception to the requirement to informed consent. So not only when you have legislation, statutes that say actually you don't need the consent of this person, there is a very pragmatic right under Right 7.4 which says there are some circumstances where the person lacks capacity or competence to consent. They don't have anyone else appointed to represent them, like a welfare guardian or an attorney under enduring power of attorney. They've gone through these steps to see whether they can actually get the views of the person, and if they can't get their views, they've asked other interested people. And then they've made a decision in the person's best interest, and so they can provide them treatment. So it's based on what we call the common law doctrine of necessity, that necessary treatment can be given to people if it's in their best interest. I mean, the obvious example would be in an emergency situation, if someone's having cardiac arrest, we don't just sort of go, oh, we can't consent, sign the consent form. We just do it because it's in their best interest. The issue with this right, or right override, is whether for more ongoing situations, if you've got a bit of time on your hands, how much can you rely on this? Okay, so the person can't consent to being put into the taxi, but actually you do just want to get them to their appointment at the outpatients clinic. But once they're there at the outpatients clinic, and then it might be decided that they need to be admitted to hospital, whether or not, in what circumstances are you going to, in any ongoing sense, be relying on this right? And that has become an issue, as I say, around the issue of the liberty interests of people who are kept in dementia units is one example, but there are others. But to say it's there, so that's another example where every day health professionals are essentially assessing a person's capacity to consent, and if they can't, and they're making even little decisions along the way, they're in essence relying on this idea of necessity in making those decisions. So the next, the other main law for mental capacity is the Protection of Personal Property Rights Act. Do you have any sort of questions about this law? So some of you may have done a capacity assessment. So someone comes to you because they want to apply to have their family member, to be their family member's welfare guardian or property manager. So when an application is made to the family court, it's often a GP, but sometimes it's a consultant psychiatrist or psychogeriatrician, will provide a capacity assessment or a report which will confirm that they lack capacity, and therefore the court can consider what intervention, such as making an order to appoint the welfare guardian. People not familiar. Yeah. So this is how most people in New Zealand will understand a capacity assessment. And there's quite a push now to, and Greg and I are involved with training GPs in particular, because they're often the first port of call around issues around guardianship. The other useful thing about this Act is that it provides for one-off personal orders. So these might be, so you're not going to appoint a whole decision maker to be making decisions, but the court says, yes, that person does need to be provided with treatment, or yes, that person does need to be placed in a rest home. And so it's used for that, as I say, and also for managing people's financial affairs. We all need to be familiar with it, and for your clientele, you need to be familiar with it, because that may well be a useful tool. One of the problems with this law is that you don't have, you've got to have a welfare guardian available. So there you are, you've got a severely impaired person that doesn't necessarily come under SACCAT, but they really do need someone to be advocating for them and assisting the services apart from making decisions in the person's best interest. And unless you can put someone forward to the court as a welfare guardian, there isn't anyone or any statutory body in New Zealand that can provide that person. So in some areas around the country, Otago is one, and I believe they've come to Christchurch, the Otago Welfare Guardian Trust, where they put forward volunteers who make themselves available. But if you're a family court lawyer like I am, dealing with this PPR Act, you get caught up in all sorts of situations in the family court debating who's the most suitable welfare guardian, and you've got siblings that don't agree, and there's lots of complications that go in with. But my point here is, so if you're in that situation and there's not going to be someone that could be appointed as a welfare guardian, as I say, there is the option of getting a personal order, which still requires two things. One, an application to the court, and two, supporting evidence, essentially, the capacity assessment that will show that the person does lack capacity, and therefore the court can take some steps to make an order. What the law is saying is that the court's not, you're free to make your decisions for yourself if you have capacity. If you don't, then in these circumstances, the court will intervene. Okay, so when you go, so to get a personal order, you need to apply to the court, and there will be, as I say, you'll need a capacity assessment. The interesting thing about this is that, and one of my arguments for revising the law, there are 4 different tests for capacity under this Act. So to get a welfare guardian, which a welfare guardian is a global decision maker, essentially, and that runs against the grain of mental capacity law in terms of just having someone that can make decisions in respect of everything. Whereas partly lacks capacity is actually much more tailored to this decision, because I'll come to this, but capacity is decision and time specific. So when, let's say, someone comes to Nova with a personal order, we'll probably say that they that they lack capacity to make decisions around having their living arrangements, okay? Or it might be that they need provision of certain treatment, but it's a specific one-off order. The thing about a court order is that there is some degree of oversight by the court, so it can be reviewed and it can be extended, and there is the protection of having or the safeguard of having a court-appointed lawyer who comes along and reports to the judge, to the court, and says, yes, I think, this required, I've interviewed the GP or whoever, and I think, yes, they have met this, what we call the jurisdiction, they've met this threshold of lacking capacity, and I've interviewed all the parties, and often these orders are made on the papers, they're not defended or litigated. In fact, as we do in the toolkit, we should rely on the functional test that appears in the English law. And interestingly, as it happens, that is the test that is in SACCAT. So that's a good start for SACCAT, because it's sort of pulled together all these different tests and come up with what we would call a core level test that can be applied. Okay? And in English law, if we just focus on this section 3, the functional test is the person is unable to make a decision for himself if he is unable to understand the information relevant to the decision, to retain that information, to use or weigh that information as part of the process of making a decision, or to communicate. Okay? So we'll come back to these elements again when we look at the SAT-CAT test, but that essentially, the SAT-CAT test essentially mirrors this functional test. In England it's slightly different because they also have what they call a diagnostic threshold. So a person who lacks capacity, if they're unable to make a decision for himself in relation to the matter because of an impairment or a disturbance in the functioning of the mind or brain. So that means that you have to be able to show that the person doesn't meet one of these 4 elements in the test, but they also have a disability but it's referred to as an impairment or disturbance of the mind or brain. And it's because of that they don't meet this sort of functional test. Now that's caused England a bit of flack because that's seen as being discriminatory under the law because it's saying that, well, it's because of your disability. But we don't need to worry about that because in New Zealand law we've only ever had this sort of functional test. But I just go back to the Triple PR Act, but to say that someone partly lacks capacity is a very low threshold and it can be used. So you might argue, well, that does enable us, particularly for vulnerable adults, to sort of get them in under the Act. But as I say, the Triple PR Act, you've got to know where to look to find the different tests for the different kinds of orders that are made on enduring powers of attorney. Now we've brought into SAT-CAT this functional test, which has been copied from the Mental Capacity Act in England and Wales. And what that means, of course, is that because we share the common law, the case law, we can draw on a lot of the English decisions. And in the Triple PR Act, I'm flicking, we talk about the person lacks capacity to understand the nature and foresee the consequences of decisions in respective matters. So that really kind of corresponds with understanding and this third element, which is use or weigh. So when we talk about unable to foresee the consequences, we're talking about unable to appreciate the consequences of a decision and to use or weigh up the risks and benefits and weigh. We'll be talking more about that, but you can sort of see there are some subtle differences, but essentially they are a similar kind of test. And the words are, and these are the things that you need to remember, and we'll come back to them. Understand, attain, use or weigh. And there's another standalone ground, and that's to communicate. So obviously someone who's had a stroke, for example, and is not using the fingerboard or anything to communicate, they may well just be knocked out on that ground alone. Now the other aspect about mental capacity law is that the UN Convention on the Rights of Persons with Disabilities has come along. New Zealand ratified it, in fact, in 2008, and it doesn't, we haven't had too much happening in and around this space. I mean, there's a lot of talk about what the convention might mean, but we haven't, for example, imported it into our domestic law. You might argue that setting up a compulsory treatment law such as SAT-CAT might have been an opportunity to build in some of the concepts. The main thing that you need to know about the convention is that it doesn't give any new rights, but it puts together in one human rights convention all the rights that are around the interests of people with disabilities, which is very broadly defined. Okay, and Article 12 is the relevant article that talks about people with impaired capacity and recognise what they talk about legal capacity, which is the idea that people should have equal recognition in law, and that under Articles 3 and 4 Article 12, 3 and 4, that states that are a party to this convention need to put in place measures for supported decision making. Okay, and what supported decision making is, the idea is that of providing support to people for them to make their own decisions where possible, rather than having other people, what they might call substitute decisions, being made for them. So it's an idea of having support so that there's a sort of a front end to decision making, which is that you should exhaust all possibilities of being able to support the person exercise their legal capacity, not only their legal standing as a person, but their agency, their ability to act on that. Now, that's all very nice, but we all know that there is that sort of other fine end, that not all people, some people may be in an unconscious state, or there may be many reasons why they can't exercise their capacity. But the idea is to get away from that binary view of having this so-called medicalised model about what capacity or not capacity means. And to a more social model about looking at what are the barriers for people to exercise their legal capacity. Okay, so it's quite an aspirational human rights convention, and the UN committee came along in 2014 and they gave quite a controversial statement about it. So they interpret the convention and said to all countries such as New Zealand, and we were one, we should abolish our compulsory treatment laws such as the Mental Health Act and our adult guardianship laws. So, well, you might say, well, throwing the baby out with the bathwater is probably not a good idea, but it has really. But the real question is, what is our policy? What are we dealing? How are we looking at really enforcing these rights? Another aspect, of course, it's not only about supported decision making; it's about providing safeguards against abuse. And so the convention talks about protecting the rights, will and preferences of people subject to convention. So aspirational, but a really important one. And so we do need to be thinking about how we can support people as much as possible. So you could argue that the SATCAT legislation is trying to exhaust supported decision-making possibilities, because it's actually saying that compulsory treatment is right down the end of a long journey when you've exhausted all other possibilities and you've come to SATCAT, you've come to be admitted under SATCAT. Having said that, there's a lot of difficulty in that whole idea of what's a voluntary and what's an involuntary patient in this setting. So, but you do need to be aware of that, and you will see. And so, for example, in our toolkit, we've talked about what supported decision making can look like, and given some tips and practice points about things that you can do to support people, even when they get to a capacity assessment. And Greg will talk about that, but they may well have a medical condition that could be fixed. Other things that they may regain their capacity. They may, and we also talk about whanangatanga as well, about making connections with people and engaging them. So that might mean drawing on family members for support. And of course, this Act does talk about whānau iwi, hapu and iwi, and the idea of support. And you could say restoring mana is about whanangatanga and the idea. And so what in my report and in the talk, what we're trying to do is kind of link the idea, this human rights idea of supported decision making with tikanga Māori, and try to say, well, come on, we're New Zealand, what's our cultural dimension? How should we look at supported decision making? So, to the Act. So everyone's aware that it replaces the Alcoholism and Drug Addiction Act 1966, which talked about voluntary detention, which sort of kind of conflict in ideas. And of course, in terms of the right not to be arbitrarily detained, and that it was quite problematic in terms of the lack of sort of safeguards in that sense. So SACCAT, we could say it's a sort of a compulsory care law. It's certainly involuntary treatment. My main point here is that it is part of what I would call a therapeutic jurisdiction, which is, it's not an adversarial thing in that sense. And so, I mean, I would like to see more training of lawyers actually in and around these areas, because we don't actually get any education on this, and it's actually regarded as kind of the lowly of the low area of law to work in. So there's criminal justice and there's mental health. I mean, I myself find it can be very, it can be a very supportive thing and very rewarding actually, representing clients. Even if you don't get them off the compulsory treatment orders and things, but you might get a smile or in some sense that you're advocating for this person. Suddenly they're in the spotlight, and actually someone's paying attention to them is actually can be part of, and then actually saying something to a judge can be a really important part of the process. So, and it's important to sort of train health and disability workers to respect that fact too, because sometimes there's a tension for, the lawyers, you're being taken to court, the lawyer's here, so you've really got to turn that around and say, well, hang on, this is about you, speaking up for yourself and taking ownership of your decisions, and that's part of regaining capacity too, isn't it? So if it does get to the point when the lawyer is maybe appointed to represent someone under this Act, think about, using the lawyer to actually, supporting the person in actually, speaking up for themselves and in a way taking some responsibility around their decisions. So it is balancing liberty interests with protection, so that's the tension that's operating here. It's a legal and an ethical tension. There are a number of law and policy considerations about, so we've talked about this, about what is the role of the state, on what basis should we have these laws, and it involves very much a sort of human rights aspect to it, and particularly it's got a lot of legal safeguards in it. So the SACCAT mirrors a lot of the rights of people under the Mental Health Act, the extent to which they are empowered through those rights is another issue. I think, for example, one of the issues is around consent to a prescription. Should people with impaired capacity, are they going to be able to really consent to their medication? So, and of course it's got the role of the district inspector is pivotal as far as these legal rights are, and that is a strong feature of New Zealand's mental health law, in my view. Having that ombudsman watchdog role of district inspectors. And as I was saying before, we're really looking at how we should interpret this in a culturally competent way, and that, as Steve's pointed out, cultural competence applies to across all cultures in terms of how we might look at cultural diversity. And the main point there too is to say, if the assessor is of a different culture from the person they are assessing, then that in itself, throws up, how we can do these things in a more culturally competent way, and it might be bringing in a cultural, support for the person through their family, or someone who has that role within the organisation. So, just in summary, these laws, they are sort of tend to be built around risk. They are risk-based. So, mental health, of course, is whether or not you meet the definition of mental disorder, and that is the phenomena of abnormality of mind, together with the first and second limb, which is around whether dangerousness, whether you're of serious risk of harm to yourself or to others. Okay. But capacity isn't a criterion in mental health. As I pointed out, there are many people that may be subject to several laws who may have, so that the clients, the people, may well be subject to this law. We also have laws that are also built around not only risk but their status, and intellectual disability. That compulsory care law is one, because you definitely have to meet the criteria of having an intellectual disability under Section 7, which is about your 70 IQ, as well as meeting sort of adaptive functioning criteria. So the Substance Addiction Act has really got a combination of all of these things, really. It's saying your status, because it is around the fact that you have a severe substance addiction. So there is, and that you're of risk to self. We'll come back to that. So you can sort of see that, and what the CRPD is trying to say is that actually we shouldn't be discriminating on the basis of a person's disability. And so there is a move in Northern Ireland, in fact, in 2016, to be sure, they've actually combined mental capacity law with compulsory mental health law and used capacity as the criteria. So it's said to be revolutionary, and we get to see how that pans out. But that's, so you can sort of see that capacity is relevant and has been relevant, and but it varies in different involuntary treatment laws as to whether it's used or not. And I've mentioned these laws, which around capacity. These have very different purposes. I mean, the Triple PR Act it has the principles of the least restrictive intervention and empowering people by maximising their participation in decisions about them. So on one level, it is, very progressive, and it's there to empower people to exercise their personal autonomy, right? A compulsory care law, now you might say there are worthy aims, but ultimately it serves quite a different purpose, doesn't it? Where the state intervenes and says, we want to compulsorily assess and treat you, so we will make decisions for you. So to enable people to receive compulsory treatment who have a severe substance addiction and their capacity to make decisions is severely impaired, so that compulsory treatment may. All of these purposes, very worthy. Has anyone got any questions about purposes of the Act? This is the one about protecting and enhancing mana and dignity. As I understand it, mana can mean different things in different contexts, so I think that's why they tend to talk about enhancing mana. That can be, difficult if you're dealing with an older person, a queer Kaumatu who is resisting treatment, doesn't want to go into care, doesn't want to be, and in terms of how that might operate, sort of respect for them in view of the perceived need to have them admitted into care. Aims, and it does have all of these sort of human rights principles, so the least restrictive possible level of coercion. So that means that you need to be thinking about what is the least restrictive intervention here at this step that I'm taking along this pathway. This is an interesting provision that reviews the patient and their principal caregiver. So if they've got a welfare guardian, there's also provision for a nominated person. So if you haven't gone through the convoluted process of appointing someone under the Triple PR Act, I think it's kind of recognising the fact that many people will not have an enduring power of attorney or an appointed welfare guardian. So there is provision for them to nominate someone to be their sort of support person. They won't be making decisions for them, but they can be nominated. So that is an element of supported decision making. But unless it's not reasonably practical or in the best interests of the patient, I mean, I find this provision a bit peculiar, to be honest, because I'm not quite sure what that's meant to mean and how you're meant to assess what the person's best interest. Then further down, it actually talks about patient-centred interest. So is that something less than best interest? Is that just your interests? And what's best? So I mean, I think these are sort of interesting things. And we see here, it actually recognises in the principles the right not to be arbitrarily detained. So this is the liberty interest. So everyone under the New Zealand Bill of Rights Act, the CRPD and other international conventions that we are a party to, has a right not to be arbitrarily detained. So that means that that's been interpreted that under the European Court of Human Rights, if you have a mental disorder or you are of unsound mind, so there is some element of diagnostic thing there, then you're entitled to legal safeguards or a process around that. So, and you could argue, well, this is exactly what this law does. It aims to do that, provide those legal safeguards. Right. So you need to know section 7, 8 and 9. That's the guts of this here. Around the definition of severe substance addiction. So just because you have that severe addiction doesn't correlate to lacking capacity. For capacity, we look at the decision that has to be made and that we apply a functional test. Right? Where people are sort of rigid in their thinking, that they're not able to consider other options, use and weigh, appreciate the consequences of, if I really do stop eating, I will die, or if I really do keep drinking, I will drink myself to death. That's part of that element, the third element, and definitely a lot of the case law is around that third element of use and weigh, because that has an evaluative component to it. So we might say that the functional test has a bit of objectivity, and so there's certain sort of approaches you can take to applying it. But in the end, there is a subjective element to it, which is your judgment about whether they can use or weigh the information. Particularly under this legislation, because there will be this initial screening test by the authorised officers, which will essentially be a capacity assessment, and then the approved specialist will be coming along afterwards and sort of seeing what the AO did first of all. So there'll be a record, there'll be data, there'll be a record of that interview and what that process, which will be looked at further along. So there'll be a question around the person's own consistency with their own views and values, which might be that I do just want to drink myself to death. So I mean, there was an English case of the King's College London and C, just a couple of years ago, about a woman, a celebrity in London, I don't know who, and she was refusing dialysis treatment, and two psychiatrists said that she, lacked capacity. But actually the judge rejected their opinions and said, looking at the use or weigh element, this was a person that was consistently expressed her values and beliefs. That they call it the sparkle case, because she had lived this high life, and she thought, and she explained this to the judge, that she would lead a miserable life when her values were that she had lived this celebrity's life, and she would no longer be able to do that, being stuck on renal dialysis, and she would prefer to die. And her daughters confirmed that that's what their mother said, and the judge in the end said, well, actually, use or weigh here, I mean, she is actually able to, within her set of values, in her worldview, make that decision. So that was, one of the decisions where, and it also shows the usefulness, can I say, of having a court come along afterwards. So even some of these decisions, the judges say, and psychiatrists, social workers, you've all done a fantastic job, and I can understand why, you've reached this position. But, it's making the legal decision, the judge is able to work through the legal test and say, well, actually, in this case, this situation, I'm prepared to accept that that's consistent with the person's own views, and that they have been able to manipulate the information and work their way through that test. So I don't know. So we looked at the severe substance addiction, and under B is this test, which has been imported from the Mental Capacity Act. There are 4 elements to it, and they're or. So you only, as it were, need fail on one, and the person is said to be unable to make informed decisions about treatment for a severe substance addiction, and they would be severely impaired, unable to. So it's about abilities. It's a task and decision-specific test. Given, first of all, understand, you need to be given the relevant information, okay? And there are English decisions that talk about, you're not to start with a blank canvas. You've got to actually give the person the option, so they actually really do, have that in front of them. Retain is, potentially that's a difficult one. We don't tend to rely on that so much in our Triple PR Act test, so it doesn't actually talk about retain, but it is retaining from a memory point of view long enough to be able to manipulate the information. Okay, so that's how long is a piece of string, you might say. But obviously, if someone really can't remember and really can't remember often, that I would have thought be relevant to their ability to be making decisions. Obviously, there are triggers, but there's also a degree of what Lord Donaldson, in quite a famous refusal of treatment case, talks about proportionality. So, obviously the seriousness of the decision and the riskiness of the behaviour has some relevance here. And you will be dealing with clients who may well be towards the end of their lives, and that, ultimately they may be drinking themselves to death. We do. So it may well be that, but you've been offered, treatment before, and you actually, 5 years ago you were admitted. Did you know that, you've actually been admitted to 10 years ago, and we know that you told the, you've got to do this in a very careful manner. I'm not trying to it's not a cross-examination, but you are putting facts in front of them that they may not believe, or but this is part of getting all the relevant information in front of them. You say, well, hang on, let's just have a look what's been happening the last few months. You turned up at A&E on that night, and I've got your daughters saying that this is happening, and so it's about painting a picture. So it's putting the relevant information, because essentially it really needs to be put to them, doesn't it, that what they're saying is not actually not true. That capacity is time specific, okay, so, but also the purpose of the Act is for them to restore their capacity, so you're really trying to find the optimal time, aren't you? What we're trying to look at is their decision-making processes, okay, not the outcome, the decision itself. Okay, so that ability to reason within using the sort of functional test. I should add that in New Zealand we have had a few cases, and one was in the prison here, Mr. All Meets All, in the Christchurch prison, where Mr. All Meets All went on a hunger strike, and so the psychiatrist concerned, I think the Corrections Service applied to the High Court to get a declaration that he lacked capacity to refuse treatment. They wanted to actually basically, give him a drip. And the judge actually, without looking at New Zealand law, looked at this test, so it's already been used in the New Zealand case law, and said, he does actually have capacity. He doesn't actually lack capacity. So you can't. It's that whole idea of not imposing your own. Well, they wanted to give him a drip. They didn't want him to die in prison. So that's the whole idea of working through. It's a procedural approach, I suppose, to work through those elements. So we'll finish my bit here with some principles of capacity assessment. Okay, so there is a presumption of capacity. A person is presumed to have capacity unless proved otherwise. So that sits in our law. So what that means is that the person that fronts up at the substance addiction service does not have to prove anything. That's your job, and you may not overturn. It may turn out you don't overturn that presumption. So it's a presumption on the person asserting that they lack capacity or they have incapacity. And the standard in law is on the balance of probabilities. So what you're trying to make a case on the balance of probabilities that this person does lack capacity because of these reasons. And I've set them out in my capacity assessment because I've worked through this functional test and I've looked at those elements, okay? So, and the presumption of capacity doesn't mean to say you don't have a duty of care. You still, in fact, there's a duty of care to assess capacity. There has been a case before the Health and Disability Commissioner where a woman with Huntington's disease lived in squalor behind a screen, and the GP sort of wanted to sort of protect her from going into care. And eventually there was a complaint, and the GP was found to be in breach of Right 4 for not providing appropriate care. And part of that was because she didn't actually assess the fact that this woman was actually, that she lacked capacity to really look after herself. So, that's an unusual situation, but it did highlight this idea that it's not, we don't just abandon, just because of the presumption of capacity, we don't just abandon people. We do have a duty of care. So this idea that it's decision specific, whether the person is able to make an informed decision about treatment for addiction, and that is severely impaired in this case. There's no, and secondly, it's time specific, so taking into account the objective to regain capacity, which is, so this is ideas that we're trying to give the person their best opportunity, as it were, for the capacity assessment. And so there's nothing that says this in the Act, but I would suggest that it just needs to be a sort of reasonable, proportionate, sort of common sense sort of approach around this. I mean, there is a risk that you could keep over-assessing people. And there are other things that you can be doing when in this process in terms of the person's treatment plan. So without saying that you shouldn't be assessing capacity at the appropriate time, you don't want to sort of overcook it as well. And then that we're talking about decision-making ability, not the decision itself. So this is this idea that we're not actually trying to decide whether or not they're making an unwise decision or not. It's whether that they've got the ability to make a decision around their treatment for their addiction. And building in that cultural dimension. It's, capacity may be restored, so you will assess their capacity. You will be putting the options to them also around what will happen to them if they're, discharged. So I think that's where I say I think we need to be very clear about what voluntary status might actually mean.